What's up, you guys? It's Mr. Taylor, back with another video, aka the Chosen One. I'm gonna start calling myself the Chosen One, because I'm definitely feeling like I was among the chosen to come put in this work, to come deliver this message. Don't hate the messenger, hate the message. So, it's been a while since y'all heard from me regarding a lengthy video going into depth. Outside of the little reels I've been doing, I haven't, done anything in about a month since my first video. So this video is a continuation of that. I'm pretty much picking up where I left off. It's not a to be continued, it's just a part 2 to that story. So the last video, for those who didn't see, it was regarding my car being booted and towed, as well as Carnet being responsible for putting me in these crazy circumstances. Come to find out, Carnet wasn't even responsible for what had happened. It was the landlord. And I just want to clarify that because everything's a part of the record. So we want to make that clear. It's not Carnet, it's the landlord. He's the one responsible for these actions that was taken. So without further ado, let's get to the video. And in this video, you're gonna learn how to exhaust your remedies. You're gonna learn how to take a person to court. And we talking about lawsuits here. And I feel it's necessary to know how this works, because a lot of us go through situations, a lot of us get our rights violated, and we don't know what to do about it, let alone bringing somebody to court. You could bring anybody to court, a lawyer, whoever. I'm bringing a lawyer to court right now. Well, I tried to. I'm gonna have to, do that all over again, but it doesn't matter who it is. Bring them to court. So, let's get into my court date that I had regarding my the booting and towing of my car, because that's pretty much where I left off, or that's pretty much the part that y'all don't know about. So I want to pick back up right there. So I went to court on the 8th of July. That was my court date, as well as the 17th. So when I went on July 8th, it was so crazy that these people, I'm talking about the clerks now, as soon as I step in the courtroom, I see the respondent sitting on the side, and I see the attorney that's representing the respondent. And it was just so funny. Like, he was pretty much telling her, don't worry about it, I got this, don't even worry. She was scared to death. She was terrified. She was like, oh my God, like, He was like, look, don't even worry about it, I got this. And I'm listening to him, I'm watching him too. So anyway, long story short, we all sitting in the courtroom, the judge is there, he's presiding over other cases and stuff. And his team, which is the clerks, they told me and the respondent, which is the city marshal and her attorney, they told all of us to come in the back of the courtroom, meaning the judge's chambers, not the back of the courtroom where everybody else is at or where people are sitting. They told me to come behind the judge. The judge's chambers is behind him. So one of the clerks was like, they called my name, and I believe they called the respondent name. I'm not even sure, but I know they called my name, and they was like, come here, y'all both could come here. I don't even know if they said a name. They was just like, y'all both could come here. However they did it. So we both came, and I'm walking to the back. I already knew it was funny. Something was fishy going on. So I walked over there, but when I entered the room, I'm like, what is this? What's going on? Like, and the lady said, well, the judge is busy, so we gonna let you plead your case back here, and I pretty much relay it to the judge. I'm like, what? Miss, I had a court date for oral argument before the judge. So I'm like, look, I am not pleading my case back here off the record. And that's because that's what it is off the record. You feel what I'm saying? You want to be in front of the judge where the stenographer could type up everything that you're saying and everything that the respondent is saying, everything that everybody is saying. If I'm in the back in the judge's chambers, there's no record. There's no record. So there's nobody typing up what's being said, and you can't appeal a case if there's no transcripts, if there's no record that's a part of that court proceeding. So I tell a lady, I'm like, look, I'm not pleading my case back here. I was scheduled for oral argument to go before the judge. So I came back out of that room and sat right in the front row now, where the judge can see my face. Before I was in like the second or third row, before they called us to come in the back. I was in the second or third row. When I came out of that room, I went in the first row. Like, Your Honor, I'm here. Like, you're gonna call this case, and I'm going to argue it before you with the stenographer typing everything up. I'm not stupid. You see how they tried to backdoor me? They tried to call the case off the record, so there's no record of it. What does that tell you? I'm in the right. So I goes before the judge. I make my arguments, the same arguments that I made reference to in my first video. I told him all of that, and I was just going in, and long story short, he denied the motion. That's what he said, but he didn't give me a written copy of it, a written decision. A written decision is going to also indicate how I could appeal the decision, how much time I got, etc. But you always get a written decision. Any other time you get that, they tell you to sit on the side for like 15 minutes, 5 minutes, whatever, and somebody going to come over and give you this paperwork. But in this case, he should have just gave the decision while I was standing there in front of him, if I'm not mistaken. He just handed to the officer, and the officer handed to me. So he denied the motion without even giving a written decision. And that's what happened on that date. Now when I went back on the 17th, they said that I don't need to be present for that. That's not oral argument. The judge is going to look at the papers and make a decision. Now the 17th was for a petition. So I guess petitions, you don't get an oral argument. That just go before the judge. He look at the respondent paperwork. He look at the petitioner's paperwork. I'm the petitioner. The respondent is the opposing party. He look at both paperwork, all paperwork, and he make a decision off of that. That's what I'm assuming happens when you file a petition. I'm going to have to read more into it. But from the looks of things, on the 8th, that was my order to show cause. On the 17th, that was my petition. On the 8th, they was allowing me to speak. They didn't even want me to speak, but I still spoke. And that's another thing you're going to learn in this video, what an order to show cause is and what a petition is. And which one you should file and so forth and so on. So, let's get into that right now. So, we also have to be aware that the clerks in the court is sabotaging people's paperwork. Because that's what I went through when I tried to file my order to show cause. the clerks tried to sabotage me filing that paperwork. And the reason why is because an order to show cause, it allows you to have a immediate hearing, immediate judicial review. With an order to show cause, the judge could actually see you that same day. Yeah, when it comes to civil court, he could see you the same day. He could preside over the case the same day and make a decision. You might have to add an emergency affidavit to it, but the order to show cause in itself, the order to show cause itself allows you to have a fast, immediate hearing, which is less than 8 days, and it can be the same day. A petition, a hearing gets scheduled by the judge, and who knows how long that's going to take. You understand? So sometimes we have emergency situations where we needed to get heard immediately, like if your utilities go out or if they shut off or something. That's something you want the judge to hear immediately. So when you put in an order to show cause, you know, it's something that can be done right away, something that can be looked at right away. So, you know, there's many differences between an order to show cause and a petition, but that's the most important part that you want to know for right now. So if you ever get into any legal issues or somebody's violating your rights, you can the best thing to do is file an order to show cause. They didn't want to let me file it that day, but then I went back to the court and filed it, and I got a hearing not too long after. So I explained the difference between a petition and an order to show cause. And also, a petition is for when you're suing somebody, an agency, not somebody personally. When you're suing an agency, so a company, something along them lines, not nobody personally. You know, when you're filing a commencement of action, a summons and complaint, which is different from a petition, that's dealing with somebody personally. So you want to know the difference between those two. And it's pretty simple. So when you filing a lawsuit, this kind of lawsuit, you can ask for money damages and all that. And this is the one I do because it's different ways to file lawsuits, but this one is pretty simple, and this is actually the right way to go. But there's multiple ways to sue somebody. You know what I'm saying? So what I want to speak on is also the difference between a commencement of action, which is just a summons and complaint, you know, and a petition. So like I said, I'm gonna say it again. A petition is when you want to sue an agency, a company, something along them lines. You're not trying to sue somebody personally. When you're trying to sue them personally and you're seeking monetary damages, you're gonna use a summons and complaint, a commencement of action, same thing, and that goes with your order to show cause. So it's either an order to show cause and a petition that you file all at the same time, or it's an order to show cause and a commencement of action / summons and complaint, and then you put in how much money you want and everything, and you can ask for a whole bunch. So I want to explain to y'all how do you start the process to even bring somebody to court. And this is very important because you know, like I said, you can know a person did something wrong to you, but you don't know how to bring them into court. And I'm pretty impressed the fact that I know how to bring somebody to court. I find it very impressive. So, first thing you want to do when you're dealing with anybody, business, company, etc., you want to ask for a card. So you would know the person's name, you know their job description, all of that. All the information is there. And you got their email address as well. Whoever, whenever, whoever you dealing with, you want to get their card so you can have their information. At least get their name and get an email that they could be reached at. Whether it's the company's email address or whether it's their personal email address. And also know who the supervisor is. You could figure that out later too, but it's always good to know right then and there. And I'm going to give y'all a quick example of what I'm talking about. So, when I put money down on my 2022 Honda Accord, I first went in there and I was conducting business with a female. She was pretty and all of that. They used her, to wheel people in and lie. And I know she was scamming me, but I just couldn't put my finger on it. At first, I really didn't know. I thought she just wanted a couple extra dollars to do what she got to do, get my insurance, whatever. This is a brand new car with no miles on it. So anyway, something told me before I left out of there to find out who her manager is. So I said, not only do I want your card, give me your manager card as well. You understand? Now, the highest person at this dealership, which is Honda dealership, the person that's at the top, the person that's in charge is the GM, the general manager. So this is what Exhausting Remedies is about. It's about working your way through the channels, through the chain of commands. You gotta make everybody aware of what's going on. Because the law states you gotta give them a chance to fix the problem before you bring it to a judge. You gotta get these people that caused the problem, give them a chance to fix the problem. So I asked her for her manager card. And to be technical, that's the person who she was talking to, running back and forth. While they running back and forth, hold on, I'll be right back. Hold on, I'll be right back. That's who's the one calling his shots, that manager. And that's why he's hiding. That's exactly why he's hiding, because he's running some type of scam. So anyway, I got home and I started emailing her, explaining to her what's going on. She started ignoring me, because I'm not going to get into what happened, because that's not what this is for. It's just an example. So, I started emailing her, explaining to her, like, look, you did X, Y, Z, you wasn't supposed to. So now, she's ignoring me, or she's telling me just a bunch of bull. So I'm like, you know what? Let me send this to your manager as well. I don't know if I CC'd it to her manager or I emailed her manager outside of emailing her, but I made sure I made him aware. And then out of nowhere, because at first they was ignoring me, they was responding but telling me a bunch of bull. Then I said, look, I want to speak to the general manager. I put it in the email and I broke it down to both of them. I said, I let her know what happened. She ain't do nothing about it. I'm letting you know, Mr. Manager, her manager. I'm letting you know what happened. You're not doing nothing about it. So now I want to speak to the general manager, please. Now, once I sent that email out requesting to speak to the general manager, that's when I finally got a call back. I don't even think I got a call back. I called and they picked up the phone. But prior to that, they would not pick up the phone. They was ignoring me. I just kept calling because I was trying to reach the general manager. And they just kept ignoring me until I sent that email out. And then I called the next day and they picked up the phone. And you want to know why? Because they see that I was exhausting my remedies. Now, exhausting your remedies is exactly what it sounds like. You pretty much using all the remedies that you have. For people that don't know what that mean, what the two words mean, you look up exhaust and you look up remedy. So, you exhaust your remedies. You use every remedy possible. And if nothing works, then that's when you get to bring a person to court. And that's how simple it is to bring a person to court. And in certain cases, you don't even need to exhaust remedies. But in certain cases, you do. So I explained the case which took place in the dealership, which I needed to exhaust my remedies. You follow me? But let's use the example when my car was booted and towed. I don't need to exhaust no remedies with that. And you want to know why? Because somebody directly did that to me. It wasn't like, there was something that took place. Just from learning law, it starts to clear up in your head. You start to understand and make sense of it. You understand? So I don't expect y'all to understand it just like that, but it can be understood real easily, just how I'm explaining it. There was nobody else for me to reach out to rectify this. There was other ways to rectify it, but I didn't have to. I don't have to go before the Department of Investigations, because that's who. If you look up who investigates actions taken by a city marshal, it's the Department of Investigations, DOI. I didn't have to go through them. I could go straight to court. Why? Because something already took place, and it was property. You see that? You ain't got it makes sense though. But when you start reading up on law, you'll understand it makes sense. The damage is already done. I didn't have to go nowhere. I didn't have to look for her supervisor or nothing. And also because technically, when you boot or tow somebody's car, you have to get a court order, like I explained. So she already went to court. You see that? Supposedly, she didn't go, but supposedly, if a city marshal comes out and boot your car and get your car towed, they already went before a judge. You follow me now? They already went before a judge. So they already got what they already got from the higher up. You don't need to speak to no supervisor about her. You follow what I'm saying? Compared to a consultant at a dealership putting extra zeros in the price of the car, putting an extra $1,000 down or something like that, that can be rectified. That can be fixed before you go to court, before you try to take them to court. And a supervisor or somebody could fix that. You feel what I'm saying? The damage is not done. The damage is done, but you could get the money back, or it could be taken off of your monthly loan, you see? So why would you take that to court when it could be fixed inside the company? And that's how the courts look at it. Don't bring this to us if you didn't exhaust your remedies and go through the chain of commands and give them a chance to fix it. You understand what I'm saying? So when they speak about exhausting remedies, you know what exhausting remedies are. You know what that is. And I just broke it down to you. So once you exhaust your remedies, if necessary, that's when you go right to court and you file that order to show cause attached with a petition, a notice of petition, Article 78 petition, or you could attach a commencement of action, which is a summons and complaint. You could attach that to the order to show cause. And that's your lawsuit right there. And you could request monetary damages in both of those motions, whether it's a Article 78 petition or it's a summons and complaint, commencement of action. Either one of those, you can ask for money. The order to show cause just get the ball rolling. and just get you a hearing. It just gets you immediate hearing, but it doesn't go into the damages and stuff like that. You don't go into too much about the claims that you're making. I think you go into it a little, but you don't go into it like you would go into it in the petition or in the summons and complaint. That's the meat and potatoes of everything right there. So, yeah, first thing first is to make sure you making everybody aware through the chain of commands, which is exhausting your remedies. You making everybody aware so they know what time it is. And if they don't do nothing about it, then that's when you file that paperwork in court and you put down everything that happened from day one, in chronological order. That's why you have to remember, and that's why the emails is important. And that's another thing I tell people: when you're dealing with these people, straight emails. We not doing no phone conversation. I know I called over the phone, but I know better. I could talk over the phone, but I know if I do talk over the phone for 2 seconds, I know to send an email making reference or pretty much stating exactly what happened, exactly what was spoken about over the phone. Excuse me for 1 second. I know better. So I do better. If I'm talking over the phone and something important is said over that phone, or it's a lie that's being said on that phone, I'm going to make reference to that in the email. So it's just like sending an email. But initially, you want to send an email out. And why is that? Because that's a legal document. Over the phone, that's why they tell you anything. Because you can't prove anything over the phone unless the conversation was recorded. And then you gotta subpoena this, subpoena that, or get the right. Emails is right there. So, and if you're lying when you're sending emails back and forth, if you're lying, there's a record of it right there. So you actually put people back against the wall when you're sending out emails, because you have to respond. People don't have to do anything if they don't want to. But if you don't respond in an email, it looks guilty. Remember what I said. Silence is approval. If I'm making allegations or I'm asking you a question or I'm requesting for you to do something, to send over this and send over that, and you're not doing it, it just makes you look guilty, my man. And you could actually print out those emails and use it as evidence in a court case, because those are legal documents. So that's why I tell everybody, emails are very powerful. Always make sure you get that card or get that email address, whether it's their email address personally or whether it's the company's email address. Either way, make sure you get it, and make sure you just do straight email when it comes to conversing. No phone. So, and that's pretty much building your case, and you pretty much putting your case together by sending out emails. And that's how I do it, and that's how anybody do it. That's how you're supposed to do it. So let's run that back real quick so y'all could really get the gist of it. So, using the dealership for an example, when a consultant did whatever she did, I was emailing her, telling her what she did. And I told her, let me speak to your supervisor. Let me speak to your manager. All of this is in an email. So she let me speak to them or whatever. Actually, I didn't even ask because I already had his email. So I started emailing him. So now I'm making him aware of the situation. You see how I'm doing that? And I'm telling him. And after I'm done telling him, I said, listen, I want to speak to the general manager now, the GM. You see? And by sending out that email, that's when they finally answered the phone. But what I'm getting at is, All those emails is what's going to go on my petition, Article 78 petition. That's what's going to go on there. I'm going to transfer all that information onto that Article 78 petition or that summons and complaint. It's going to be transferred over. So you're already putting your case together when you're sending out emails. You see that? You're just making the transition. That's all you're doing, is making the transition from point A to point B. I told you how to exhaust your remedies. And I told you how to start an action in court. You just file that papers. But first you have to exhaust your remedies. And that's pretty much the lesson for today. You know, I wanted to get that out because I've been having y'all waiting for a while. It's been a month since my first video. So I wanted to keep y'all posted on what happened on the court date. I haven't really been in the mood like that, but the show must continue. I haven't been in the mood like that. You know, something just told me today, get it out the way. This ain't nothing. I already told y'all, from scruffy or not in the mood or whatever, the message is what's important. And that's why I said that, because it'd be a lot going on. It'd be problem after problem. And that's why I'm going to just start making videos of all of these problems. You know, and also teaching people at the same time. So, we pretty much touched on everything. I don't want to make this another 40-minute video. People are like, yo, you should make your videos shorter. I'm like, they like, you just starting out, you should make it about 5, 10, 15 minutes tops. I'm like, look, what I'm talking about, it takes longer than that. So whether I'm just starting out or not, I have to make these videos long because, and it's not even that I have to, they're gonna be long because we're talking about some real stuff. So you learned what an order to show cause is. You learned what that is. You learned what an Article 78 petition is. You learned how to exhaust your remedies and bring a person to court, going through the chain of commands. And you learned that emails are very important. Whenever you're dealing with anybody, email. Especially if you see they moving funny, email. You want to know why? Just think of it as a text. But this is serious. Text could be used as a legal document. I'm not for sure about that. But it could be used as evidence in court, I would think. But the email is even more solid. Because that's through Google. That's Google right there. So, yeah. The emails is powerful. Just text them. Use it as think of it as a text. And just text everything. Just put they back against the wall. That's what I do. You know, as soon as I get their email, you want to do something funny, I just revisit exactly what you did. I'd be like, on such and such date, I came to your office, you did such and such. They be getting mad. They be like, yo, talk. I'm telling you, one lawyer was like, yo, talk to me over the phone. Because I don't want to do this email stuff. I was dying laughing. You don't want to do this email shit. You don't want to do it. Because you know how serious this is. As soon as you start emailing them, they already know what time it is. That's when they fall in place. Because they know. These emails, if he's emailing me, this is a record. And from the looks of it, he's going to go through the chain of commands. He's not a stupid one. He's not using a phone. He's conversing with me via email. So once you do that off the bat, they already know. Yeah, this guy's kind of dangerous. It looked like he's trying to bring something to small claims court. Or he's trying to bring something to the bigger court. Whatever court it is. He know the next step is going to court. Once he go through my manager. Let alone he don't want his manager or his supervisor to see that. So that's what I'm saying. You know, you get all the email addresses. And even if you ask them, when you ask them via email, they got to answer. And if they don't, because they don't have to do nothing if they don't want to. If they don't, that's guilty. You're guilty. So that's why you have to respond. I say it all the time. You have to. You have to. You don't respond, it's going to make you look bad. If I say, look, I need to reach your supervisor or something. Could you please provide me with their email address or their phone number? And they don't do it, you're in trouble, buddy. Makes you look even worse. And when I show that to the judge, it's not going to be a good look for you. So, I think I covered everything in this video. And once again, you know, I learned something. I thought Con Air was responsible for my situation. Couldn't find out it was my landlord. And he's getting sued for it. So I hope he's ready. And you learn something every day, man. So now I'm learning landlord and tenant law. You know, I'm always learning something. And that's how you gotta do it. So I see you guys on the next video, and I just hope I didn't forget nothing. But I think I touched on everything that's involved in this case. And oh yeah. So come to find out, as far as my case is concerned, they didn't even make a decision yet. I heard the judge make a decision verbally, but when I wrote to court, they wrote me back. I got the paper. They said no decision has been made yet. Then come to find out, I'm hearing that one of the clerks is telling me he got 60 days to make a decision. This is crazy. But I got documentation saying that there was no decision made from the court date on July 8th. I got the paperwork that says it. And one of the clerks was asking me when I was in the back of the courtroom, she was like, what's your number? What's your number? As if they're going to call me one day and say, come get your car. And that's what I feel they're going to do. Probably not. But, you know, it's no decision made. It just sound like some backdoor stuff that they're doing. You know, like when they got a messed up case and somebody in central booking, they call them to the side and be like, yo, just go out the side door. That's one of these cases. Because they already tried to pull me in the judge's chambers to plead my case off the record. And yeah, don't be afraid to speak on the record. All of y'all going to court, whether it's criminal, civil, for one, make sure you know what you're talking about. But don't ever, ever let them scare you into being quiet and not speaking on the record. Because that's what they want. The first thing they'll say, your attorney is professional. I think you should let your attorney speak. Yeah. I want to speak though. You know, he don't have my best interest. You saying he has my best interest. He don't. He or she don't. And I want to speak on a record. They don't like that. They don't want you to speak on a record because it's being recorded. Or typed up by a stenographer. So don't ever be scared to speak on a record. And that's why they tried to have me plead my case off the record. So you tried to make me plead my case off the record. The judge says that the motion is denied, but don't give me a written decision. Then when I write the court, they say it wasn't a decision made. You got the clerks, one of the clerks asking me to write down my number. For what? We in court right now. What am I writing down my number for? So you can call me later or something? What are you calling me for? Yeah, Mr. Taylor, come get your car. They're going to do... You see how they try to just slide me in the back? This how crooked these people makes you think they won't be like, yo, look, your car's over here, parked over here. Come get it. Yo, these people... They funny, son. These people are frauds, man. Falsifying documents. They frauds. But yo, that's it. I think I'm done. And if there's any more to talk about, we're gonna make it in the next video. Peace.